Welcome everyone to this special sofa series pupillage edition webinar. I'm just going to wait a couple of minutes for all of you to join in from the waiting room. So if you could just hold on just for a minute or two, and then we'll get started. You should see on your screens, we have 5 panelists today. So we're very happy to be joined by Alex Aldridge from Legal Cheek, and then 4 members of Chambers from Essex Court. So I will let each of them introduce themselves in a minute, and I'll just wait a couple more minutes for people to join us. So I think everyone is coming through.
77 so far, which is good.
Yeah.
There's a chat, isn't there? Chat function. I'm gonna try the chat. So
great.
There we go. So
great.
Hey everyone. So and do ask us questions through the chat, guys. You know, like it's I think we've got what 78. So we've got loads of questions, but you can ask us your questions spontaneously through the chat.
We'll do our best to cover all angles.
Yeah, but I mean, first of all, thanks a lot thanks to everyone for joining us. What we're going to do today, so we have received lots of questions via Twitter and email over the last couple of days. We've picked 15 questions that we thought would be helpful to cover. So that's our plan, is just to sort of go through them and deal with those questions. But as Alex has said, please do jump in on the chat if you've got questions about things, either things that arise from what we're saying or things that you've been wondering about. I'm going to let everyone introduce themselves now, but just to give you a bit of background. So 3 of us on the panel today were involved in the pupillage recruitment process this year for Essex Court. So Beatrice, Sarah and I were involved in the paper sift and the interviews. Jen Wright is our current pupil, soon to be newest tenant at Essex Court, and I've already introduced Alex from Legal Cheek. So I'll let each of them say a word or two about themselves. I'm Remi Reichhold. I'm a junior member of Chambers at Essex Court, and I do mainly sort of public law and public international law, and a member of the Pupillage Committee.
My name's Beatrice Collier. I'm also at Essex, and together with my friend and colleague Georgina Wolfe, I co-host the Pupillage Podcast, which, as you might have guessed, is a podcast about the tricky business of securing pupillage. We talk to loads of barristers, judges, other legal professionals in order to get their advice and insights. It's available on Spotify, iTunes, SoundCloud and Mixcloud.
Hi, I'm Sarah Adelby. I'm also a member of Chambers. I joined Chambers a couple of years ago now. So I was also part of the pupillage process in my last Chambers. So I have a good idea of how different chambers approach things.
Hi, my name's Jennifer Wright. As Remi said, I was the pupil at Essex Court this year. I'm very pleased to be a tenant starting in September. And I did about 3-4 months of my pupillage more or less remotely. So hopefully can bring something of that experience to this.
Hi, I'm Alex Aldridge, the founder and publisher of Legal Cheek. It's just sort of weird that I'm on a panel about getting a pupillage, because I did the bar course and I didn't get a pupillage, and that's one of the reasons that I started Legal Cheek. So I'm not sure how well positioned I am to give advice on getting a pupillage, but I can certainly give kind of general advice about graduate recruitment and the sort of thing. We Legal Cheek, we work with lots of chambers and firms, and the sort of things that they're looking for at the moment from prospective pupils at this sort of strange, unprecedented time.
Great. Well, we've already had a very tricky question in the chat, so we will try and do our best to answer that. But I guess we can start with the questions that we've already received. So I think, Alex, you've got the first one.
Okay, first question is, so do I need a first-class degree to become a barrister. So as someone without a first class degree who's not a barrister, I'm putting this out to Beatrice, Sarah and Jennifer. Have any of you got, and Remi, have any of you got first for a start off with? No. So two of you definitely don't. Two of you might. So Remi and Beatrice. So there you go. You don't need one. So, yeah. But do you need to go to Oxford or Cambridge? Because often it's like first or Oxbridge.
No.
No, Sarah. So no first, no Oxbridge.
I think that's a relatively easy one, Alex. I think I have a 2-1 degree from a non-Oxbridge university at undergrad. It's not a barrier at all. I mean, certainly a first-class degree will help you. That's for sure. But it's not a bar to getting pupillage and becoming a successful barrister.
I think, however, we have to be realistic that there are some sets where they really do want, I don't know that they want pupils who have first-class degrees, but they select pupils who have first-class degrees. For example, I had a quick look at Blackstone Chambers, and the sort of bottom, I think 7 junior tenants, all of whom have first-class degrees, and some of them distinctions in postgraduate work. So I think the thing to do is look at the sets that you're interested in and look at the qualifications of their junior tenants, and you'll get a sense of which sets, although it may not be an official criterion, are interested in that. But other than that, absolutely not. I think actually I've got a statistic there that might help, that from the Bar Standards Board, which is that 40% of those with a very competent and a 2-1 obtained pupillage. So that's something to bear in mind. And 85% of those with an outstanding and a first class obtained pupillage. So you can see that, as Remi says, probably makes a difference, of course, but it's by no means a barrier if you don't have a first class degree. I would say probably that I have no evidence to support this, but I reckon probably more barristers don't have first class degrees than do.
What you do have to do, though, wouldn't you say for barristers, though, you've got to be, one, very intelligent, and two, a real interest and love for the law. So do you think that's fair? Whereas solicitors, it's more often they're, like the law but don't love it, interested in business. Whereas the barristers are the ones who've got the real love for the law. Do you think that's fair?
I think it will really depend on what area of practice that you end up thinking that you want to go into. And I think that it is probably generally proper to say that you have to be ready to read a lot more cases as a barrister than you might necessarily do so as a solicitor. So you should at least enjoy the stories that come from them. But there are certainly areas of practice where the law doesn't play a regular feature in your day-to-day work. So when I was in my last chambers, we were a broad common law set, and part of your practice in your first 2 years in chambers involved really anything that the clerks could throw at you. And I tended to find that when I did criminal matters and family matters, I very rarely referred to cases or legal principles in the sense that they were sort of understood, so you don't have to go into it in the same way that you might necessarily have to do if you had a public law practice.
I think the only thing I'd add to that is that you can't underestimate the value of people skills. Client care is increasingly important, and if you have a first-class degree but you can't get on with your clients, you can't be amenable to the judge, you can't be persuasive, it requires a rounder package than just having top sort of academics. They help, but they're certainly not everything.
Yeah, I'd absolutely support that. I certainly have interviewed people who have really decorated academics, fantastic. Clearly they have that analytical ability, but in interview they just didn't have the ability to persuade or even advocate on their own behalf. And I think that is a real key skill when you're a barrister.
People instruct you because you can do the job, but also because they like you and they can trust you with their clients.
And what's
right,
what's
so
the
shall I move on to the next one? The next question is it more difficult to get a pupillage or a training contract? Can I apply for both?
So I had a quick look around just before we started at some of the statistics. I know you have to bear in mind that some of these are based on extrapolation from various reports from the Law Society and the Bar Council. First, I think in the 2018 Law Society report, it tended to suggest that there are about 5,000 above around that figure training contracts available, and of those who were admitted to the role, you had about 7,000, which tended to suggest that you've got a pretty high percentage chance if you were doing a sort of direct correlation. Whereas by contrast, in the most recent rounds, and this is based on Gateway data, there were about 2,000 applicants for pupillage through the Gateway, and there were 135 offers of pupillage made. And so you can see there's a real difference there. So I think in terms of purely statistics, it might suggest that it is more difficult to get pupillage. That's on numbers. But I think there are probably a lot of other factors that come into it, and bearing in mind that of that 2,000, there may be repeat applicants who are coming through. There may be people who actually decided going through the pupillage process that having a career at the bar wasn't for them. And obviously, the training contract data will take into account the applications to a magic circle as well as the applications to high street solicitors. And it will depend on whether or not you want to go to the magic circle. And if you're looking at that data on its own, whether or not that would be comparatively more difficult to getting pupillage. In terms of can you apply for both, I think theoretically it is possible. Applications for training contracts can arise as early as in your university degree, whereas an application for pupillage, I think the earliest you can reasonably apply is at the end of your third year. And so you could do both of them, but I would certainly say that if you are thinking about applying for both, have you spent enough time thinking about what you really want? Because that can come across in your application form, whether you've gone through the process, thought about the experience you need to tick both careers boxes in order to make a really solid application.
I would agree with all of that, and I would just signpost people to an article in Chambers and Partners Student, which you can get online, that has quite a sort of good, relatively in-depth analysis of the various statistics. I mean, as Sarah says, you sort of need to be aware that they don't tell the whole story, but it sort of breaks it down into more detail, sort of magic circle firms versus others, and so on and so forth.
Yeah, I think I'd add also that there is increasing overlap to some extent between the two professions, but I think for a lot of people they do still remain like quite different jobs which require different skill sets, and I think you could very much enjoy one and not enjoy the other, you know, depending on what it requires of you. So I think I'd echo what Sarah said about, Sarah said, my apologies, about thinking about what is it that really draws you to each of the jobs. You know, have you thought hard about what skills you're going to need to exercise? Or do you need to do a bit more thinking in order to make a decision? Because obviously the amount of time and effort it takes to put in applications and make those applications good, you don't want to be spreading yourself too thinly.
One thing that I've noticed from speaking to Chambers over recent years is that they've said broadly they've seen a little bit of a drop off in application numbers, and they think some of that is students who would have previously applied for pupillages, and instead they're looking at training contracts at top firms like US and Magic Circle firms. And those firms there's so much more out there on campus. There's so much more marketing material for those firms. And they also offer sponsored law school, which, you know, you can obviously get that at the bar through the Inns of Court, but that's not as well publicized among undergraduate students as it is. So actually now, and the other thing I think the bar's suffered from a bit in recent years is just in a broad sense, the students have this idea that the bar's maybe not doing well because they think, oh, that's legal aid, criminal barristers, and it's tough for them at the moment. And they don't realize that, that there's lots of different types of practice areas. I mean, you know, this is sort of kind of undergraduate level, but I think, so actually it might not be a bad time if you are really wanting to be a barrister and you're kind of thinking, should I be a barrister? Should I be a solicitor to go for the bar at the moment? But I mean, as Sarah said, the stats are definitely in your favor if you're applying for a training contract still.
Great, thanks a lot, Alex. Sorry, just before you move on to the third question, I think I'm just having a look at the questions we received in the chat, and I think there's one that really overlaps with what the question you're about to ask, which is from from Richard. Richard Nicol has asked a question, and I think that's probably a better way of dealing with it. So Richard is asking, what is the most common way an applicant can rule him or herself out of contention? Is there any particular common error that people make in making an application or an interview over and above the stuff like spelling and grammar?
Interesting.
I mean, I think if having sifted a large number of pupillage applications this year, for me, the most instructive part of a pupillage application form is always the questions that deal specifically with chambers you're applying to. So almost all chambers will have a question along the lines of, why are you applying to this chambers, or why are you interested in our practice areas? And for me, those are always the most important questions, and those are the ones I think where most people fall down. Because lots of people will have brilliant application forms, fantastic academic credentials, clearly very, very bright, have done loads and loads of incredible things, but then they might be applying for a public law pupillage and saying they want to do crime, or they haven't identified any of the practice areas that a particular chambers does. So I think for me, that's probably the most common thing that would rule someone out.
I absolutely agree. Actually, when you read out the question, Remi, I noted down to myself tailoring your application to the chambers that you are applying to, and the questions about why you've selected chambers are really important. It is also important to look at it in terms of your overall application. What are what the pieces of experience that you are referring to? Why are they relevant to that chambers? From my perspective, if you have done all your mini pupillages at commercial sets, and then you're applying to 5 Essex Court, whilst we do some commercial work, we're not a commercial set. And so I would start to wonder why you have applied to us, and it makes it more apparent if you haven't explained what seems like a shift in interest in your application form. So tailoring is a really big part. And if you and I absolutely get, because I remember rushing through doing all of those applications and the deadline coming up, and you've got loads to say, and some applications require you to include responses to problem questions, but getting a really good solid application requires you to tailor it to the particular set to make you stand out, because it makes the reader feel like you're speaking to them. And not in the sense that you want to be like them, but in the sense that you appear as though you've really thought about this, and that this is a career that you want to have, and this is a set in which you want that career to happen.
I think it's the point that Sarah makes about work experience and it being tailored is a really critical one. So I just want to underline that it's not just what you put in the box about why you want to belong to, why you want to apply to a certain set, but also what the rest of your CV says about that statement that you put in the box. So for example, experience at a housing charity is going to work really, really, really well for some sets, but it really isn't going to speak to a defamation set as so. And I see a lot of excellent applicants who just, as far as I can tell from their applications, are really headed in a different direction, ideally. And they are competing with people who seem to want to head in the same direction as our set is heading.
It is possible. I mean, using Beatrice's example, it is possible to tailor it to say that your work in a housing charity would work in a defamation set, because you can obviously style that as saying, I'm really used to working with clients who have high emotion, who take things very personally, who are going to feel like they have a real personal stake in the outcome because it affects the very body of themselves. And that's how you can kind of link it to your experience. It's not saying that those pieces of experience are irrelevant, but it's going over your application and saying, you know, if I was from this set, would this really speak to me?
Yeah, I completely agree with everything you've both said. I mean, I should say I haven't sifted application forms, so this is a much more limited range of experience, but I think it's helpful to think of your written application as a piece of written advocacy. So plan it carefully, think about all of the elements that you need to include, make sure that they are kind of evenly distributed, and as you've both said, make sure that you evidence every claim that you make, which is incredibly easily, you know, not to do. But I think you need to structure it so that the whole thing itself is a persuasive piece of writing, because that is demonstrating exactly the skill that people are looking for, persuasive advocacy.
I have to say, Jen, that really resonates with me, because I remember when I was drafting my pupillage application forms, the best piece of advice I was ever given was to basically draft it with thinking that it is a skeleton argument for yourself. And that's what an application form is. So as concise as possible, very carefully drafted, you know, obviously all the obvious points about spelling and grammar, but really it is a piece of advocacy. And everything that is in it needs to be there for a reason and for a purpose. We're going to have to move on, I'm afraid. We've got lots
just before we, sorry, Remi, can I just say, just before we move on, can I just say it isn't actually uncommon, though, to make lots of applications and not to have a great deal of success first time round. So people do find that second time round or third time round, they do get better at it. Sorry, I just wanted to offer that before we move on. That's
really helpful. So the next question we have, I think, is a very straightforward one. It is, and again, we're picking up all the questions from the chat, but we're going to work them into the order that works best. But the next question I've got is, if you've been turned down for pupillage this year, should I reapply to the same chambers next year? I think from my perspective, the answer is certainly for our chambers, for Essex Court, we blind mark all the applications at PaperSift. So we don't see your name, we don't see even the university you attend when we do the PaperSift. So actually, unless you tell us that you applied last year, the person marking your application won't know that. Different chambers have different approaches. I do think there are a few chambers that will keep a note of people they've turned down. But I think the best way of dealing with that is if it's not clear from the chamber's website, there's nothing wrong with sending chambers an email and saying, I was interviewed last year, or I applied last year and was turned down, you know, will I be penalized for reapplying this year?
If you had some success, even if you didn't achieve the pupillage, so for example, if you got through to the second round of interview, I would say that's definitely an encouragement to apply again.
Yeah. And we've certainly had candidates recently who have even, I think we had one candidate recently who was a reserve 1 year, didn't quite make it, and was our first choice the next year after that. So it just goes, I think that's a very good point, Pete.
We've had in the chat a question of, does your application form need to be really different, or should you keep it similar if you got an interview at that set the previous year? Well, I think in terms of its core, yes, you can keep it the same. It obviously fared well, but in the year that between applications, it is an opportunity to even bolster your application so that you've got more to talk about if you get through to the interview again. And I think that's true even if you didn't get an interview. When you don't get through in the first round, then take it as an opportunity to diversify, to strengthen yourself, and be really self-critical about your application. What do you think you're missing if you were looking at people's chambers profiles? What do you think that the person who is already in chambers has that you haven't got? And is there a way that you can get that onto your CV or demonstrate that you are an even stronger candidate when you apply again.
So Jen, you've got the next question, and I've noticed that we've actually had that question just pop up in the chat. So, so you might want to pick up on that one, the question from Rosie.
Yeah, so Rosie's question is, do you have any advice on how to show interest in a particular practice area if you've been unable to apply for example, minis due to coronavirus this year? So I imagine this is something that people are probably quite concerned about, and certainly quite a prescient issue. You know, if you can't get into a chambers and meet people and get to know it that way, how do you demonstrate interest, and, you know, how do you choose?
I mean, I suppose with that, you've got to look at it, right? So, okay, you've not done a mini pupillage, but there's so much information about, you know, practice area. It's just an area of life, an area of business, whatever. There's so much information out there. There's too much information out there, you know? And so, you know, you should really be able to think, rather than just think, oh, you know, I haven't done I mean, a mini pupillage, just following someone around for a few days, can be incredibly boring. Whereas, you know, you could actually just think, okay, I'm just going to read up massively about this area, and I'm going to, and that would get you a lot. You might get a different sort of experience, a different kind of insight, but certainly you would, you know, I think there's certainly enough that you could use as on the basis for something. There's so many webinars going on at the moment, particularly chambers are conducting loads of webinars for their solicitor clients. So you could be proactive. You could read up about a particular practice area. Then you could get in touch with the chambers like 5 Essex and say, right, I want to attend one of your webinars about a particular area of law that solicitors are attending. And, you know, so I think there's loads of options for that personally.
And my answer is actually also going to include something that's just been asked in the chat about, you know, if you don't get feedback after an interview, how could that be improved? And actually my answer to that question is, certainly for us, we publish a pupillage report every year, which talks about ourselves, which talks about our process. That means that you can demonstrate you have paid attention to our chambers because you've taken the time to read that. And that, as Beatrice said in her introduction, she and Georgina Wolf host a Pupillage podcast. That's great ways to know more about chambers. If you popped onto Chambers website and looked at people's profiles or in their news, you'll see cases that they've been involved in. And so you can go and read those and have an opinion about it yourself. You don't need to say that you agree with what was being argued by Chambers, but you're demonstrating that you've taken the time to research more about that practice area so that you can reassure yourself that that is what you want to do and what you want to be arguing about when you qualify as a barrister.
I think that's...
Sorry, B. I was just going to say, just in relation to the feedback question that we were asked, perhaps more in defence of chambers in general and the bar, I think one of the things to bear in mind is that I think the reason that almost all chambers don't give feedback to candidates at the paper sift is simply because there isn't the capacity to do that. It's not because chambers are being mean or don't care about applicants. It's simply because chambers work very differently in comparison to law firms. So when law firms run training contracts, there's often an HR department that will take care of that. Whereas on the from a chamber's perspective, most chambers operate in the way that barristers will have to sift the forms. So to give you an idea, I think this year we received about 350 application forms. There were 4 or 5 of us who were responsible for sifting those forms. And there simply aren't enough hours in the day for us to give feedback to 350 people on an individual basis. So I'm afraid that's the sort of realistic answer to that question. But as Sarah said, we do try to give as much feedback as we can in our report. And we did this year, we gave feedback to every single person that we interviewed this year at first and second round.
Yeah. The only thing I'd add, perhaps just following on from something Alex said about sort of getting to know chambers with Rosie's question, make use of the resources which are there from the Inn and from your university if you're in legal education. So I know with my careers department, our careers officer was often able to find somebody who was, you know, a previous student working in a particular area, perhaps even working at the chambers that you're interested in, who might be willing to have coffee with you or answer an email. Use the INS mentoring scheme. My understanding is that that's still running. That can be a really good way to talk to somebody who's in the profession, who can give you a sense of the atmosphere of a chambers, which is perhaps goes behind the public face that a chambers put out in terms of sort of promotion and websites and things like that. And they can tell you perhaps more what it might actually be like to work there. So I think there are resources there, and it can be really valuable to use them.
Okay, so who's got the next question then? Is it me?
Thank you.
Yes.
It's me. Okay.
Yeah.
Right. So let me just get this. Okay. So this question is, I think this has come in on the chat, and it's as a non-law graduate, I worry that perhaps I'm a less attractive candidate when applying for pupillages. What do you advise for an individual in my position to do as a means of building their portfolio? Pro bono work seems to be one of the suggestions. I just think it's a very negative question, I have to say, right? So it's like, don't worry about being like, you know, there's loads of non-law students that become lawyers, right? It's about 50%. So don't worry about stuff like this. Just think, well, you know, like Lord Newburgh is a non-law graduate, like half of lawyers are, right? So rather than start like worrying about it, I think, okay, you're not, well, first of all, you're not less attractive. You're just like pretty equally attractive as anyone else. And then I'd think about, okay, well, how do I play to my strengths as a non-law graduate? So it depends. You're not going to be a great expert. Well, it depends how much law you've done. But if you haven't studied any law yet, you're not going to be a great expert on law, but you will be an expert on the subject you studied, or at least have some kind of insight into the subject you studied. And you probably, I'd imagine would be a good starting point. You could do.
I remember that a few years ago, Lord Sumption gave a very extended address about how actually non-law graduates were better than law graduates at being lawyers, which I think upset those of us who had invested our time in studying law. But that's certainly, Alex is 100% correct. What you are trying to say that you have is a really great analytical ability. So if you studied history and you are familiar at working with source material and drawing conclusions from that, then you've got a degree that will be suitable to the bar. I mean, obviously, I think Legally Blonde is probably a little bit of a stretch. If you're a fashion graduate and then decide you want to be a lawyer, you might need to add a little bit more in there to say that you've got the skills to be a lawyer. But being a non-law graduate and is absolutely at least 50% of us who are practicing as a barrister.
And actually, fashion law is a fast-growing area of law at the moment. That's so. If you are a fashion grad, great. You've got an insight into a valuable industry. You'll go and get your legal skills. Fantastic. Perfect.
I have to say, I agree completely. I mean, I did law undergrad. And if there was one thing I could go back and change, I'd go and do something more fun at undergrad.
Absolutely.
You know, I mean, if you have a burning passion and desire to read about contract law as a 19-year-old in university, by all means do it. But if you're more interested in something else, it's not going to hold you back.
Because as I think Jen mentioned earlier on in this chat, people skills, commercial awareness, all sorts of other skills and experience are just as important, and you can, after all, in the end, learn the law, so it's not a problem.
Yeah, no, I'd certainly echo that. I wasn't a law undergraduate, so yeah, I haven't honestly found it a barrier at all. In fact, sometimes it can be quite nice, particularly in interviews, to have something to talk about that you know more about than anyone else in the room. That can be quite a comfortable feeling, you know. So no, I don't think it's a barrier at all. Perhaps again, as I think Beatrice mentioned earlier, it might be useful to look at the juniors at different sets to get a sense of whether a chambers has a preference. I don't personally know how common that is, but it's certainly something I've heard. So it might be worth looking at the juniors and seeing, do they all have law degrees? But it strikes me as equally possible that a preference would cut the other way. So, it's about what skills you have and how you sell them rather than how you got them, I think.
Shall we move on then to another question which we've received on the chat? This is a question from Emma, thank you. And Emma says, I appreciate that this will be difficult for the panel to predict, but what do you think the future holds for pupillage recruitment in light of the pandemic? Do you envisage fewer places being offered? What can an applicant do in this time to really stand out?
Okay, can I just, one thing that you're going to see is virtual pupillage fairs. And in fact, Legal Cheek has got 2 virtual pupillage fairs coming up, one at the beginning of October, one at the beginning of December. Now, this is a great way for students, because at the moment, the whole pupillage recruitment system is geared towards London unfairly because all chambers are in, most chambers are in London. So now suddenly students from all over the country can get in front of chambers, including elite sets like 5 Essex Court and its rivals, and speak to their barristers, and like you are doing right now, listening to their barristers. So in this virtual event, so that's great. In terms of numbers of pupillages, why would they fall? So like we've got a recession. During a recession, you normally get more litigation. This is good for barristers, and so you're probably, if anything, in terms of the business model of commercial and top public law sets, it's been seen as an extremely good, efficient business model. People have talked a long time, the bar is going to get taken over by law firms. It hasn't happened. Why? Because chambers have such a ruthlessly lean business model, which is more lean than most startups. So I think you're probably going to get, I don't think, you might get a little hit in the short term for about a year of there's fewer pupillages. That might happen. But long term, there's no reason to see that. And if you want to go into legal aid, you might actually be at a point where there's going to be more. Certainly, there's not going to be any cuts to legal aid funding in the current climate. Given the government's largesse, you might actually get more legal aid funding. So I would feel positive about pupillage numbers. Not that there's going to be loads of them, but yeah, that's my take.
It's great to have such an optimistic take, and I agree about pupillage numbers. I do think it is probably likely, however, that there will be more applicants than usual next year, because this year some chambers decided to halt their recruitment process, which means that there'll be some people who will be needing to apply again next year. So whilst maybe the same number of pupillages, I think it's probably realistic to expect there to be more people competing for them. I'm not sure what other panel members think.
I think that it's correct to say it's hard to predict, because we are still in the thick of what the aftermath of the pandemic is doing. And I imagine that there are many chambers who are taking stock of how that is going to impact their work in the long term. I certainly agree with Alex to the extent that from my perspective, and this is a very personal perspective, the law has sort of been put on a slight pause rather than stopped completely, which has bottlenecked. And so we will reopen when we are allowed to go back to court in a more fulsome way, in the way that we did beforehand. But I imagine that chambers will start looking at the availability of work so that they can genuinely take on people who they want to keep. For our perspective, we take the number of pupils who we have space to keep on as tenants, because we don't do the sort of here's 12 pupillages for one tenancy space. So it's hard to know at this point, but there are chambers that are still recruiting. In terms of the actual recruitment process, we held our interviews completely virtually. So we had our meetings through Skype, and there were some technical problems, as I think probably we've all experienced when we've used these platforms, but for the most part it was fantastic, and we were able to identify our next year's pupils through the platform. So I don't think that there's been any real hindrance from us in terms of pushing forward the pupillage process.
And we've had a related question about whether it would be worth delaying the bar course this year because of the high number of applications. I think that's a very, very tricky question. And I think it's tricky because I think different people have different views about the bar course. Some barristers will tell you that you can and should get a pupillage before the bar course if you can. Some chambers will maybe expect you to have some knowledge that you would have acquired on the bar course in your interviews. I think it's really a personal decision. I think you shouldn't do the bar course unless you're absolutely sure that you want to pursue a career at the bar. I think that's the key thing. And the second thing is, I know that the Inns of Court offer about 400 scholarships a year for the bar course. And I think maybe that's one way of looking at it, is saying, actually, if I can get a scholarship for the bar course, that it takes the financial pressure off and it makes it a slightly easier decision.
I tell you, I'll say what I would do if I was in this situation as a sort of like middling 2-1 graduate. I don't know if you are, you might be a first from Oxbridge, I don't know, but I would say, don't do the bar course, get a training, go instead, get a training contract. There's more chances of that at the moment. Then if you still want to be a barrister down the line, cross-qualify and become a barrister. More and more students are doing that. It's a tough market at the moment. And the bar is going to take a hit for a year or two. So I wouldn't put your plans on ice, but I'd do that. Or I just wouldn't go into law, and I would like look at kind of a fast growing other area that you might want to get a job in. You know, stuff like cybersecurity is booming at the moment, virtual events. You know, I'd think a bit more creative. I wouldn't turn your nose up on stuff. And, you know, again, getting a good bit of experience in another industry and then saying, you know, a year or two later saying, okay, now I want to do law, you'll be in a great position because you'll have developed some really good experience. So I'm not, you know, that's what I would do personally.
I mean, sorry.
Oh, sorry, Jen, you go ahead.
No, I was just going to add that I wouldn't underestimate how much time it can take to assemble a full and persuasive application in terms of getting all of the experience that you need. So Remi, of course, mentioned that, you know, you might, so some application questions might rely on a bit of knowledge that you might pick up on the bar course. I think there's also something to be said for me, you know, coming over, not having done law. I definitely got a level of immersion during the bar course, just in the legal world, that was pretty necessary. But, you know, bear in mind, lots of people apply again after finishing the bar course. So I think if you are thinking of delaying it, it's worth thinking about how long it can take some people to get it anyway. But I mean, ultimately, it's difficult to advise, because I think if you go for the bar, even in the best of times, there is an element of unrealistically backing yourself against the statistics, which may or may not be wise, but I think it's essentially just a deeply personal decision about whether you're willing to take those risks and, you know, whether your life permits it.
So I'm going to move on to the next question, which there have been some variants of the same question on the chat. But the question we had been given was, will I be penalised if I can't do mini-pupillages this year? Obviously, in terms of making pupillage applications.
I think you will if you like go into it with an attitude of just like, oh my God, I'm so disadvantaged. But if you actually, as I've said before, if you actually take proactive steps to think creatively about what you can do to make up for that, I think you could turn it to your advantage.
I think there are some sects who are trying to come up with a sort of remote form of mini pupillage. So it's definitely worth exploring, first of all, before what there is out there, and seeing what you can do to take advantage of that. And as I think it was Remi who mentioned this earlier, it actually might be easier to do a remote mini pupillage than it is to sort of have to get some time off studying, time off work and travel and pay for it. So that might be an opportunity. And I agree with what Alex says, that as with everything, it's the people who are most resourceful who are likely to be noticed. And as we've seen throughout the pandemic, that there are ways in which people can thrive. And with this, if you can't do we've covered quite a lot about what you do in order to find out about chambers and practice areas. And that really is the point of the mini pupillage, so that you can use it as an information gathering exercise. And so really it's about finding other routes to gather that information, which is, I think, something that we've covered.
And I think certainly in our set, the Pupillage Committee, we've discussed this, that certainly when it comes to sifting applications next year, we will have in mind that it will have been more difficult for people to do mini pupillages this year during the pandemic. And that's something that we're going to be alive to and take into consideration.
Sorry, B, go for it.
I was just going to sort of say a related point. I think that all STEPs are going to have to think about their applicants when it comes to assessing their applications next year, because, for example, qualifications, there are many people whose degrees this year have been acquired on the basis of their predicted grades or of their grades last year. And I think we as pupillage providers have to be really sensitive to the fact that different universities have taken a very different approach to how they're going to handle people's finals, their students' finals. I think the onus is on us to inform ourselves, but equally, I think it's important for applicants to help those who are undertaking the SIFT and to explain what their situation is.
Also, I'm just going to say something. I think that mini pupillages are completely overrated, right? So I did about 20 of them. I hated them. I actually hated work experience. I hated all work experience. I just I felt like a spare part. I felt it was not useful at all. And I know a lot of people do like it, but it's not for everyone. And, you know, there's students out there like collecting mini pupillages, and it's just like, God, you know, you do a couple, you get a broad sense of what it's like, you know. It's not the be all and end all, you know.
Well, I think that links to another question that we've been asked in the chat, which is there an advantage for doing a mini pupillage at a place that you want to do pupillage at? And I think that the reality, unfortunately, is when you're a pupil, you also feel a bit like a spare part, even though you're getting to do some work as well to test your skills. So there is some reality reflected in having a mini pupillage, because you are mostly following somebody around and then engaging in conversation with them and then drafting advices and pieces of paperwork. And so in some ways a mini pupillage is sort of learning by osmosis in that sense. Do you have an advantage if you do a mini pupillage at a place that you want to do pupillage? It will depend on how you appraise yourself and appraise the situation when you are at the mini pupillage. What are you using the mini pupillage for? Are you asking people questions about how they like it in chambers, what their work is like, what is their work-life balance, how are people interacting? Are you observing how other barristers in chambers interact, or even if they interact at all? Because I suspect that almost all chambers will say that they are a friendly environment. Those sorts of things are inherently subjective. Do you think it's a friendly environment from being there? And having done a mini pupillage in a place that you want to do pupillage gives you that advantage, because it gives you the advantage of being able to say, do you know what, this place is for me, or this place is not for me. A mini pupillage is just as much about your experience as it is about us seeing that you've done them on your application form. So in some senses, yes, it gives you something to talk about in your application form to that place that you're applying for pupillage.
Thanks, Sarah. I'm going to move on to the next question. We've had a number of people who've sort of asked this question in different ways, but effectively it is. What can applicants do now to get advocacy experience? So, for instance, Holly has asked about getting experience in the current climate. Lawrence has said that the pupillage process has become maybe more Darwinian because of the virus. And so what are people's sort of views on that, on getting advocacy experience and relevant experience during the pandemic?
Well, I had a look earlier, and I've noticed that there are virtual mooting competitions running. So, I mean, I wouldn't overlook those. They obviously do involve a time commitment, but there are sometimes lightning moots. which are obviously a bit briefer. And I think it's experience worth gaining. So although it is a time commitment, it might be worth time putting in. The other thing I'd suggest is don't perhaps neglect written advocacy. So essay competitions, I would imagine, are unaffected by COVID. I'm told that relatively few people tend to enter them, and they often have reasonable prizes. So I'd certainly say, you know, shop around, see what else might fill that gap, even if you can't be doing kind of in-person advocacy.
I think it's important also to sort of keep checking different organisations, because this is a dynamic situation. So, for example, the Free Representation Unit, FRU, its latest information on its website from a couple of days ago is that it aims to train volunteers in October and November, and some of that will be virtually, I understand, but they anticipate that those people will be ready to take cases in December. And I think that these organisations still are experiencing a lot of demand. In fact, some of them maybe more than before, and are doing their best in order to try and overcome the problem about not being able to do things in person. So it's worth just, rather than just checking once and thinking, oh, well, that's no good, you know, maybe look back in a couple of weeks and see what's happening.
Should we move on to the next question?
The next one is this.
So this question, I think, has come in on the chat. So I haven't got the name here, but so I hear obtaining a 2-2 will make obtaining pupillage impossible. What if someone is a mature entrant to the profession after a career change? How can one demonstrate that they're not having a midlife crisis, but that now is the time for them? So, I mean, from my experience, I worked for about sort of 10 years, I guess, after graduating, before moving over to law. I haven't found it a hindrance. I have friends who've done similar sorts of things. I mean, I think maybe something that's come up throughout this is you need to think about what skills do you need to evidence, and there are often multiple different ways of evidencing those skills. But I mean, if you have experience working in a professional context, you have experience working with clients, you're used to putting in a full working day, you know, I mean, I think often you might have something that other candidates don't have. So I certainly wouldn't think that it's a barrier. And certainly relevant work experience is exactly the sort of thing that I would imagine might overcome perhaps a degree which is not quite as good as you hoped it would be. I'm not sure what the rest of you think about that.
Alex, I know I've seen an article on Legal Cheek about getting a 2-2 and whether you can get pupillage. I mean, I can certainly tell you that from the perspective of our set at 5 Essex Court, we have a policy whereby we certainly don't rule out applicants with a 2-2. But what we ask for is we say that you would need to be able to demonstrate in some other way being able to produce work at that level. So whether that's a master's degree, or if you've done some other type of work, it doesn't necessarily have to be legal, but to be able to show that you'd be able to produce work at that level.
I mean, it all goes back to being this idea, you know, being an expert in the law, really able and loving the law. And so, you know, say if you've got a 2-2 in a non-law degree and then you've got a distinction in a GDL, then, you know, fine. You know, some chambers might rule you out, but you'd still have a good chance. But if you've got a 2-2 in law and it's because you're not that good at law and you don't love that law that much, don't be a barrister. But your life's not over. Like, do something else. There's a lot of other things you can do with your life. But you're not going to be happy being a barrister if you're not really into law and good at law. So and there are, you know, every year a few people, like a really small percentage of people with a 2-2 manage to get a pupillage, but it is a small percentage, and often that is not in the really kind of hard law chambers. It'll be more doing, you know, but it'll be in areas which would be perhaps more focused on people skills rather than like real complex chancery law problems or whatever. But, you know, as general advice, I'd say probably if you've got a 2-2 in law, don't be a barrister. Do something else. That's fine. But you see, barristers will never say that to you. And, you know, you're worried about saying that in these kind of public situations because you think, oh my God, will I influence their life choices and discourage them and everything? But, you know, you've got to use your common sense a bit as well. But I think that pretty much covers that. But we do a few articles on Legal Cheek about that. And in the comments, people argue about that at great length. So you can check those out. I think I've got a question that was come in on the chat. So from someone who is working full-time and studying part-time, I really struggle to add pro bono minis into my CV, especially now. Any advice on applying for pupillage? I'm worried I'll get accused of not wanting it enough. I think I think in terms of like this idea of not wanting it enough, I think in life generally, you can tell with people who want stuff or don't want stuff, right? And it's probably not that much to do with like doing some minis and ticking some boxes on your CV. You can tell when someone really, really wants something, and you can tell when they are not that bothered. And like, if you're working full-time and you're studying part-time, well, that's one thing that says you do want something, you do want to do something different, right? And so I'd focus on that. I mean, it all sound, all this pro bono minis, it's very box ticking-y, you know. Just think about in other areas where you convey, where you want something. So I wouldn't worry about that at all. And if you've got a chambers that says, oh, you haven't done this, then probably not the right step for you anyway.
I think all power to you. It is really hard to work full-time and study part-time, and I can only sympathize. It is really hectic to do both of those. But I worked through parts of I flipped it around. So I was working part-time and studying full-time, and it can be really fulsome. I think that if you feel like there are lots of gaps in your CV as a result of it, being patient with the process and saying, you know, maybe I can't build up this experience. What I will do is I'll make these applications and do what we've said earlier, really research chambers, really demonstrate that you have knowledge of the law, or try and focus on getting one portion of that application full. So if, say, your application it doesn't have many mini-pupillages in it, well, at the moment it's a great time to have a look for things, because you can do things virtually, as we said in our earlier comments, and there are some chambers who are holding virtual open days. And I think that I hope we're not reaching commercial privilege when I say that we're also thinking about doing something similar. So take advantage of this time where you can do things virtually. In terms of advocacy, again, try and look at options that you can do online. And I think there is a real flawed view of these pieces of work as they come onto CVs, because I think as an applicant, you look at this as, oh, well, the chambers wants me to tick all these boxes, but you actually have to flip it on its head. This isn't just for us to see that you want to be a barrister. This is for you to see that you want to be a barrister. You are being asked to consider a career which theoretically you might want to stay in for 50 plus years. Are you going to be happy standing in front of somebody and having them shout at you for half an hour, even when you didn't do anything wrong? Are you going to be happy working all of these hours on your own? Because the part of being a barrister is that you are self-employed and you don't have that same interaction. You don't get supervision, you don't get appraisals. You can talk to people in chambers about your work problems in the sense that you can analyze it with them. But when you go into court or when you write your piece of work, that is all on you. Do you like that? And I personally, when I have when I have mini pupils with me, I really try and highlight that you are making a choice for yourself, for your future. Do you like this? And that's important. And those pieces of experience that you pick up is to inform you about your life choice. So try and think of it that way. And if you think of it that way and say, you know, I don't have the time for this at the moment, but actually it's something that I really want to think about. and I really should get more experience of, to tell myself, yes, I'm convinced that this is for me, then you should go and do that. And I think that is really important. And it does help you in your application to explain, why do you think you will be a good barrister? So there are ways around it. Sometimes it may be, certainly some chambers will have that as a really rigid tick box. So you have to say that you have got a mini pupillage, have pro bono experience, have mooting experience. And if you can't get that all in 1 year of application, then the next year do it. And that's what I did. So when I went through my first round of pupillage applications, I didn't have enough pro bono experience from my own appraisal of my application form. And then I stopped studying, and I used my spare time to volunteer at a pro bono centre, and I added that to my CV so that I could plug that gap. And then I looked at my CV and I thought, you know what, I don't feel like I have academics that really demonstrate that I am exceptional at the legal part. So I saved up from my job and I went and did a master's. You have to be realistic with yourself and your application about what you think you need to put in there if you're not getting the answer that you want.
Yeah,
I think that's just excellent advice. Yeah.
No, completely agree. And you should also think about, in terms of getting the experience and the kind of the material to put into the application, think about how you're going to present it, because you may have done all sorts of very relevant volunteering. You don't speak about it in a way that shows that you learned something from it, that you've gained skills by virtue of doing it, then you may as well not have done it. You know, it's not just a tick box exercise. So I mean, you can get skills in all sorts of different ways, but I think it's also definitely possible to have technically fulfilled these different criteria, but also just not show that you took anything from it. So it's not just a question of doing it.
I have nothing to add to that. Those are, I think, really helpful answers to that question. We're running a little bit short of time. We've got a couple of questions left. I'm going to combine the next two because they're quite similar. We were asked about tips for doing virtual interviews, and also asked whether pupillage will be held virtually. So I don't know if any of the panel members have any sort of answers to those questions that they'd like to share.
On virtual interviews, because we're doing a lot of virtual events at the moment with Legal Cheek, and so you know, it's the basics. So it's making sure that you've got a good internet connection. Surprising amount of people actually don't. So just checking if you don't have a good internet connection, sitting near your router is important. External mic, that really does help your sound quality. There's different ones you can get, that helps a lot. Backdrop, I don't have the most impressive backdrop here, but you know, you could, I don't know, I mean, just so it's neat, the room is neat behind you, that you're in a quiet room, there's not other people, and things like that, it'll throw you off completely if you've got noise and things, and it's just making sure you've done, you know, just get used to the technology. If it's on Zoom or whatever platform, you've used it before, so you're comfortable with it. But not underestimating those things.
I definitely agree with that. I would just add, if the technology goes wrong, we know it's not your fault, so don't get flustered by it.
But it might be your fault if you haven't prepared properly.
I think we held all our interviews remotely this year, and I think we were all pleasantly surprised. I think that it worked really well. We didn't have any, I didn't feel like we had any problems or issues, or that it sort of impeded the process in any way. But certainly our first and second round interviews were all done remotely. And as to whether pupillages will be held remotely, I think we're going to have to hold fire on that and see what September and October bring. But I think it's likely that I think some elements of pupillage, certainly in the first 6 for this year, may have some remote elements to it. We've had another question as well we've had lots of questions about applying from outside the UK. So people with an international background. We've been asked about whether chambers sponsor visas, and one advice we have for people who have schooling from other countries I think I have a couple of points just to make on that. I mean, I think if you're applying from an international background, there's absolutely nothing to prevent you from becoming a barrister in the UK, subject to being able to meet visa requirements or whatever you would need to be able to work in the UK.
And just on that, Remi, I understand, and I will be corrected if I'm wrong, the Bar Council or the Bar Standards Board, I can't remember which one, do have a license to sponsor foreign applicants, so those who will require a visa. So there is a process. You have to look it up, but I certainly am aware of it. Yeah,
that's absolutely right. There's also, we have an applicant a pupil who'll be starting with us soon, who's come across to the bar having done the bar transfer test. And there are lots of people at the bar from lots of different countries. So it's absolutely possible to do that. But one thing that's really important is whether you have an international background in that you're coming to practice in the UK from another country, or whether you have an international background because you're interested in international law, whatever your interpretation of international background might be, at the end of the day, you will still need to show Chambers that you have a burning desire to join that Chambers and to do their practice areas. So I think that's really important to keep in mind.
I think we had a related question, which was about, let me just look for it in the chat, about someone saying if they had a non-British accent, whether that was going to be an impediment.
Yeah.
And on that one, well, firstly, I'd say there's someone in our set who wouldn't mind me saying if they have an accent, and he's certainly extremely successful. Again, I think you need to apply a bit of common sense, because it is about the job does require you to speak for a living, and therefore you do need to be understood. But beyond that, I wouldn't say that it's an impediment.
Beatrice, we've also had a question about whether someone would be disadvantaged if they're dyslexic. And the person asking the question has said that the approach they take is simply not to put it on the form in case they may be disadvantaged by that.
I would say you wouldn't be disadvantaged. I would say that if you think that it's a real concern, put it on the application form. There is a section that says, do you have any mitigating circumstances? Well, my first supervisor, when I was a pupil, was dyslexic, and he got me to check all of his work before it got sent out. So, help yourself along if you're worried about making small errors, and ask somebody to proofread your application for you. It's not cheating. You're just asking someone to run their eyes over it. So yes, mention it. No, it's not a disadvantage.
I mean, I would say that the work, I mean, this probably varies with different areas of law, but you should keep in mind that in certain areas, certainly in the area that I work in, you will be doing an extraordinarily large amount of writing. So I think as long as you're comfortable with doing that, if writing is a painful process, then be aware that you may be doing an awful lot of it. But I mean, essentially, if you're comfortable with that and you're happy to do that, then I don't think it's necessarily an impediment.
Something like this, there's no one size fits all. It's like there was a great journalist, A.A. Gill, who died a few years ago. He was dyslexic, and he couldn't even write any articles. He had to say them, and someone else would write them down. And he was probably the best columnist at the Sunday Times. So I suppose in a sense, that for his career, being dyslexic was a disadvantage. But then it kind of became an advantage because he didn't have to write anything. He just dictated everything. So, but there's a lot of different types of personality and blah, blah, blah. And it all depends. But yeah.
I think we're just about out of time, but the last question I think we'll be able to answer. We've had two questions about whether we are going to be running mini-pupillages for the 31st of July deadline this year. The answer is, I'm afraid probably not. We are reviewing the situation. I think what we're looking at doing is we're hoping that we're going to be able to run something remotely. We don't know exactly how it's going to work yet or what it's going to look like, but we're going to get back to applicants as soon as we possibly can on that. I think we've answered almost every question that we've received. I hope it's been helpful. I want to say a really big thank you to Alex for joining us and for giving up his time today. It's been really fantastic to have your input, and thanks a lot as well to Beatrice and Sarah and Jen for joining us. And I hope it's been helpful for all of you, and wishing you all the very best in your applications for next year. So thanks very much.
Thanks.
Bye-bye.
Bye.